Okay, this is part two. This is a copy of an objection I filed on the 29th. I was showing my other videos. I showed a motion to vacate. I also filed an objection. What an objection really is it's called a judicial review, which is further proof that these are administrative hearings inside family court. Because why do you need a judicial review? And there's a thing called the Administrative Procedure Act. It's a federal law where what happened was a bunch of companies back in the day, they'd have these administrative hearings for employees, and they would circumvent their constitutional rights. Now, you're entitled to due process all the time, even during administrative hearings, but there's a different standard for due process. But as part of the due process, you're entitled to judicial review. Now, Family Court Act 439, which is to support magistrates get their purported power, it says in the like two times her orders must be signed by a judge or they lack legal force. So that tells you right there they have no legal force. They might have administrative force, but again, I'm not an employee, so none of this stuff applies to me. So an objection is a judicial review. So in the last video, you heard this. It's hard to hear her, and she was like, "Well, what did the judge say in the objection?" Now they call it a review. See how slick they are? They call it a review. So when the objection starts, the judge is very careful in the way she words it. Let it be. No, this is a judicial. This is a review. She doesn't say it's a review, and then she says, "Well, I wasn't there, so I got to go by the recordings, the audio, and the paperwork." So in other words, it's like an appellate review, and it's hearsay. So she can't make any determination. She wasn't there. So think about it. You got a judge, a family court judge, who's doing a judicial review who wasn't there, not heard anything. And I already told you they docked the testimony because I spent $1,100 on transcripts, and I caught them like taking out so much stuff it'll blow your mind. So in the review, the judge, like she dismissed my. I was telling you yesterday in one of my videos. She dismissed it because allegedly I sent it to this clown's wrong address. Like, again, this guy's a creep. He has 3 different addresses, and how I caught one of my attorneys was she was sending it to 41st Street, and the guy lived whatever the last 2 numbers on his address was 08, and his real address is 04, but there is no 08. It doesn't exist. So she was supposedly sending it there. She wasn't mailing it anywhere. It's a scam. So they weren't cooperating. So what happens is you show up to court. I sent the papers. Well, I didn't get them. Well, I sent them. Well, I didn't get them. Okay, now listen, you guys. I'm playing the role of the magistrate. All right, you guys gotta. You know what? Make sure you send the paper. Why don't you just send it? Certified mail, or call each other. That's how I caught my attorney. I go, well, why don't you call them up? And she goes, oh, well, we'll order not to. I go, what are you talking about? So it was all a scam. So 3 months in between the hearing dates, they're not communicating at all, and they're not sending. It was unbelievable what was going on in there. So in the judicial review, it states that that she can't really make any determination because she wasn't there. So like it's unbelievable. But they do that because they have to give it to me in administrative hearings. They have to give me a judicial review for it to be as part of the standards in the Administrative Procedure Act. So all right, let me play this. Let me stop yapping so you can hear. And this is gonna get hot and heavy now. Wait do you hear this? This is gonna be classic.
That's the reason I filed objections, very honestly, because that covers the law.
No, but that's, no. I listen to the law. But we had stated at that time, we had a discussion in which you stated, yes, she will be seeking it back to the date of filing.
No.
Well, the judge has remanded it for a de novo hearing on that.
Now, by the way, she just said back to the date of filing. I showed you guys in earlier videos. They went back to 2007. So right there, she went back to 2007. The date of filing was September 15, 2010, and this date here was 11/4/2013. Think about that. It's 3 years after we're still going over this. So right there, she just said we're going to go back to the date. And that, by the way, that's true. You can't go before the date of petition. There's a statute of limitation on crimes, but not in civil court. Civil court, when you go to civil court, you can only proceed from the date of petition. That's like when you're getting divorced. As soon as you file for divorce, everything stops. The clock stops until you file your agreement and everything's agreed upon. So whatever like pension you have, it stops on the date that you file the divorce for the get the index number.
There was an issue about going back on the unreimbursed, the percentages, but that's very, it's like $100 and some odd dollars. It's not
Right,
really-
so that's the other thing that I had a little issue about, the percentages that changed, because what I wanted to see was, where is that in the divorce state, that if there was no exchange of the incomes, then if you were to come to court, was it going to be a CSSA guidelines, or was it going to remain the same?
No, CSSS.
So then the
CSSA was
percentage
waived. It was waived in our agreement. It was waived.
No, it said to be computed in accordance with the CSA based
So when
upon.
the
No,
CSSA
CSSA was waived.
Sir, no one's talking to you
Because
right
you're not going to let me
now.
speak. You've done it a
We are
million
not
times.
talking
You
to
have to
you.
take turns. Let
Okay, are you going to let me speak? You're going to let me speak when it's my turn, though, right?
Because
They
then
never let me
it's
speak, by the way.
CSSA guidelines. Then it's the guidelines. The guidelines will then come across as the percentages change too.
You go about the unreimbursed?
Yeah.
But the unreimbursed is $100 and some odd dollars at the end of it.
No.
We won't
There's
concern
something
with
in the
this.
judge's decision which says that because it was 2/3 and 1/3, and I changed it to 67/35, which is different from the 2/3 and
No,
1/3.
I think honestly, there was only.
Now, right there, this maniac is she's talking about the education. Now, since when does family court have anything to do with education percentages? Because in our agreement, because I made 2/3, I made 2.5 times her salary. I had to pay I agreed to pay 66% of the education, which is no law that you have to pay for. By the way, that's another thing. Anybody getting divorced, don't agree to pay college. Don't agree to pay any. I don't give a fuck if they were going. You just say no. You don't agree to pay for anything other than the percentages. That's the acceptable percentages for child support. Don't ever agree to anything else because it's more stuff you're gonna argue about. And this maniac was fucking around with the percentages of the tuition. What happened was my daughter was in college, and in our agreement, and it's a law. It's also the federal law. As soon as the kid's in college and living on campus, you don't have to pay child support anymore. Because if you're paying the kids room and board, why would you got to pay child support if the kid's not living at home anymore? So that's what brought us into this court, because my greedy ex-wife couldn't live on $650 a week. And when my daughter went to a very expensive college that I didn't agree on, I took whatever money I was paying in room and board, I took off the child support. And these maniacs telling me I wasn't allowed to do that.
One of them, the unreimbursed medical, was 75/25. And I think that the decision
Exactly,
followed the
right. I otherwise kept it everything in 2/3 and 1/3.
Again, that wasn't the big
Ongoing
issue.
college.
I didn't file objections based upon that anyway. Mine only went to the arrears and the council fees. That they had to go back to the date of the breach, which was in '07, where the adjustment was not made pursuant to the stipulation of settlement.
Now, when you had given me in your written submissions, had you gone back to the date of the 2007?
Yes, that's why later, in fact, you observed that I did it very precisely. I did it year by year by year, period by period by period, to take you through it so it would be very crystal clear. So I think the only thing that has to be done at this point is Judge Lubov didn't award between May 1 of '07 and the end of January of 12, or 13 rather, didn't award the 1133 and change her bi-weekly paycheck. She reduced it the way you had it at 867.
Now, I was inexperienced, obviously. Obviously, I should have been like yelling out objection and objection. I didn't know what I was really doing back then, because it was only like my third time in there, second time, and they bulldoze you. You hear them, and she just ignores me. I'm standing there with my face red, and they're doing it on purpose. They just look at each other, and I had my hand up, and she was just ignoring me this whole time. What I'm going to do is I'm going to stop. This will be part 2. And I promise you, I'm just trying to give you a good narrative of what was going on. I mean, this is good stuff. If you listen to this stuff, I mean, what I'm trying to do is keep anybody out of there. Don't ever go there. I got tricked. I got tricked. I thought by going there with the lawyers that it was going to be okay. And I got tricked, and it was a very, very big mistake. But, I'm an honest person. You don't realize it when you go to attorneys. You're dealing with some serious organized crime. Family court is serious organized crime. As I put in one of my descriptions, if Italians, Irish, or black people were doing this, they'd call it the RICO Act, racketeering. But when lawyers, judges, and politicians do it, they call it the Family Court Act. So it's okay. It's comedy.